Now let's hear with part 28 of the My Docket series on Corazon real estate. We are going into the motion. Sorry, before I talk about the documents, let's talk about the hearings. I'm really frustrated that I don't have the video. They don't have the video because apparently they didn't record these automatically. So without a request, no video. No transcript is available either. Apparently, without requesting a court reporter to report the hearing, they don't do that automatically either. So this is one of the things that caught me off guard. I thought I would have a video. I really wanted to show you guys because it's the first, well, and only example that I would have had of me representing myself not in a child custody case. I remember the hearing going well. I remember feeling the judge treated me very fairly. I remember the attorney also treated me fairly. The attorney who'd been preparing the documents, which I think her name is Katherine Parks, she was just sitting in the audience. They sent another attorney to do oral arguments. The arguments, I feel like they went well. The only thing that I can remember is that the judge, well, I can remember a few things. I guess we'll talk about them. I remember the judge asking how old I was. I think he was surprised when I told him I was 29, but I don't remember how he was surprised. Maybe he asked me another question about how I learned about all of these, how I learned about the law and all that stuff. And I remember talking about whether the court was going to consider it as a summary judgment motion or not. And he said he didn't have to say that. He could just decide to do it. I'm not sure if that's true or not. I remember discussing, I remember arguing all of the points that I made in the briefs really well. I also remember arguing that if the court felt that there was a lack of jurisdiction because of the monetary issue, that there was a law that would allow him to send the case to the justice court rather than just dismiss it. And he said that he said that he had discretion, so he could just decide what he wanted to do. And of course, I don't think that's true because they have the abuse of discretion standard. Just because you have discretion doesn't mean you can do whatever you want. It is possible for you to abuse your discretion. Um, that's all I really have. I'm so sorry, guys, that I don't have the video. We would have been such a good opportunity to show a different sort of side of me representing myself that didn't involve child custody, and I was so looking forward to that. Um, the arbitrations. See, I have a few memories of the arbitrations. I never actually saw the arbitrator in person, but I do remember at least two phone calls. One phone call that was just kind of an automatic initial discovery issue where I was offering to allow them to bifurcate the punitive damage portions of the case. And I think the attorney was confused because she opposed it just because I asked for it when actually it would have been beneficial to them. So in hindsight, I mean, it's not my fault that she got confused. It's better to not ask for things that benefit the other side. If they want to ask for something, then they can ask for it. Don't do that because then it gets all weird in briefing because it's like, hold on, that's beneficial to them. How do they respond to that? Is it an opposition? I mean, to ask to give them something that protects them. And of course, when you're trying to just show that you're not trying to be harassing or a vexatious litigant, you think in your head, I'm trying to, prove myself. And so it leads you into doing things you shouldn't do. Bifurcating the punitive damages portion is beneficial to them. If they want to do that, they can ask for that. I shouldn't have asked for that for them just to be nice. There was also a second call because they failed to respond to the discovery. And there was an opportunity for the request for admissions to be deemed admitted. And I remember abandoning that. In hindsight, I probably shouldn't have done that. I probably should have stuck that to them. But I also want to say that I don't think it would have mattered. I think that the court would have just exercised its discretion to not deem them admitted, to just order them to comply within a certain amount of time. And I think she would have complied because she actually did comply. I think that their excuse was that a legal secretary did not hand the documents over to them. They blamed it on the secretary. Doesn't matter. I do not feel like the court would have deemed the request for admissions admitted. I just don't think so. And I like 95% sure he would have just said, you have an extension, and they would have complied with the extension for sure because she did. If you want to learn more about discovery, watch the video discovery. You can also take a look at requests for admissions. Now, I think I can go into my mindset, which is, of course, very scared. I always hated going in and making oral arguments without an attorney. It was the weakest thing. It was my weak point because with, like I mentioned before, with documents, you can backspace, you can copy, paste, change, or rearrange. But when you're speaking, whatever you say comes out. It was always where I felt the attorney had the real advantage because they were used to doing that. They were accustomed to it. Whereas me, what I don't know, I'd been into maybe 10 hearings at the time. I mean, that's something, but attorneys have probably been into, 10 hearings in 3 days. No, I'm just kidding. I guess it would depend on the jurisdiction. A Vegas attorney, probably 10 hearings in a week, maybe even more. A Washoe, maybe maybe three or four. It depends. It's different up there. They don't set hearings all the time like they do down in Vegas. All that being said, I guess we should go into the court's order. Yeah, let's go into the court's order. Let's go ahead now and take a look at what the judge has filed. Here we have the judge's order granting the motion for judgment on the pleadings. I don't actually remember reading this, so I'm very interested to read it. Let's see. Okay. Plaintiff appeared in proper person. Defendant appeared through counsel. Court's in receipt of the motion. Are they mentioning the strike? They're not mentioning any of the striking stuff. Former tenant-landlord relationship. Summary eviction was held. The Sparks Justice Court ordered the half the cost paid, which is outside the jurisdiction of the Justice of the Peace, by the way. This is a subject matter jurisdiction issue here. The Justice of the Peace can't do that. Defendant with written notice of intent to terminate the underlying lease agreement vacated. 12C, let's see. If the pleadings are closed, it provides a means of disposing cases when the material facts are not in dispute. All of this is under the early case termination video. Okay, wait. Such a motion has utility only when the material... Okay, I thought he was going into summary judgment analysis. I haven't seen that yet. Let's keep going. Principal difference between motions filed pursuant to Rule 12b and 12c is the time of filing, because both motions are functionally identical, which is true. Federal cases interpreting the federal rules of civil procedure are strong persuasive authority in Nevada. That's also true. The court has decided to decide the matter under 12b-5, which is, what is this, failure to state a claim? Yeah, okay, that's what I suspected. This is valid. Nevada's notice pleading. Complaint needs only set forth sufficient facts. Adequate notice of the claim and relief sought. Reviewing motions to dismiss under 12b-5, the district court must construe the pleadings liberally, accept all factual allegations, draw inferences in favor of the non-movement. Judgment on the pleadings. First and second claims for relief are relating to the alleged wrongful eviction have to be dismissed because based on the documents submitted to the court, not evicted. So he's saying that he agrees that the threat isn't enough, that you have to actually have been evicted. Is there any case law? He's using the jurisdictional threshold to say that without punitive damages, then there isn't enough. And then, of course, the conversion, which I actually agree with. He's using best efforts, but this is too early. Intrinsically related to the first claim. Okay, so let's see what the discussion is. So yeah, he's using the coerced. So this is actually a really good point, because if landlords can threaten to evict you and then actually trigger you moving out to avoid the eviction being on your record, then they can come to court and say we didn't evict him because on his own he moved out, which is what happened here. This is really fishy, and I wonder if there's a case that says he's allowed to do this. Okay, so here he is again asking for evidence or documentation. This is not proper under the 12b-5 standard. So this is, so far I'm leaning towards this being reversible. So he's recognizing that a claim for retaliatory eviction might fail when there is evidence. Again, you can't consider evidence. It's too early. So he's stuck on this. This is why he gets overturned. He's not following the rules for early case termination. You can do this later during the summary judgment mid-case termination phase, but by then more evidence comes out. And there's also affidavits and declarations that are considered and stuff like that. So this is why I got the deal that I got. I'm going to talk more about the deal in a second. Let me wait till the end of this video, guys. Defendant failed to timely repair. 14 days after receipt. Defendant did not fully repair within the time prescribed by the law. The plaintiff, so I don't understand how he's saying that the defendant did not fully repair within the time limit. You know, this is one of the things that I think is tricky. It's not so much that they didn't actually repair it within the time limit, so much as they said, we didn't repair it within the time limit. We're going to make you pay the rent for it anyway. And since you're trying to use the law that allows you to withhold rent for that portion of time, we're going to evict you. It's that eviction portion that opens up the punitive damage door. That's where I'm going to continue reading to see if he comes up with that, or if he analyzes the punitive damage stuff. Okay, here we go. Claims have to be in excess of 10K. The actual damages do not exceed 10K, which is true. Unspecified punitive damages are sufficient to meet the court's jurisdictional requirement. Okay, and he's also connecting the retaliatory eviction statute to the punitive. So he's doing the same thing that the defense said. Where does he say that? He says that he's saying that to the contrary, relevant case law suggests. So even the court is using weak language. So I'm going to talk about the deal at the end, and I'm going to mention why I think I got this deal, because the judge and the attorneys knew that this was a shaky order. And I'm seeing that it's a shaky order. He's trying to say that you can only recover punitive damages under the wrongful eviction / retaliatory eviction, but he knows, and I think the attorneys know, that that is just one of the things that I brought up, and that the other thing, which is the trying to transfer the repair costs onto the tenant, is the actual concern that I think the attorneys had. If this was a slam dunk case, then I wouldn't have gotten the deal. We'll keep going. Conversion. So this is something that I agree with. It still could have been amended, though. Doesn't he talk about the amending? He doesn't bring up futility. So this really hurts them, because then there's one problem, which is the analysis under the failure to state a claim. But then there's a second problem, which is that if the allegations aren't good enough, then there is a basis to allow somebody to amend. So there's too many ways for this to be reversed. I'm going to go through all the other documents, and then I'll talk about the end of the case. All right. Certificate of service indicating this document was mailed to me and electronically served on the attorney. Notice of entry of order. If you guys want to learn more about what the notice of entry of order does, watch my video on the topic notice of entry of order. It sets the time limit to file an appeal. That's the nutshell. There's more to it than that. Certificate of service under Rule 5 indicating the notice of entry of order was mailed to me. And then they filed a verified memorandum of costs. And let's see here. So they're trying to get $521.90 in costs for the entire case. They're not going to collect any of it. They waive this. And again, that's going to go into the deal. So we'll talk about that soon. If you want to learn more about how that works, please watch my video on the topic costs. I think it's called attorney fees and costs. Certificate of service under Rule 5 indicating this memorandum of costs was sent to me. Index of exhibits, documents regarding costs. Okay, that's the end of that. Oh, wait a minute. Hey guys, there should be an exhibit attached to this. I wish I would have gotten it. I'm going to just get the exhibit after I finish this video. And if you really want to look at this exhibit, just go down into the description below, click on the link, download it for yourself, and take a look. It's probably just some kind of receipt or something. Notice of appeal. So I filed a notice of appeal of the order granting motion for judgment on the pleadings. Rule 5 certificate of service indicating this document was personally served on the attorneys. Case appeal statement, which was prepared by the clerk of the court. And guys, you've seen these so many times. If you want to learn more about the case appeal statement, please watch my video on the topic, filing an appeal. And then a certificate of clerk and transmittal, which is just a document from the clerk indicating that they transmitted the appeal to the Supreme Court of Nevada. Okay. I wonder if there's another document filed in this case or if this is the end. No, there's nothing else. Well, there's minutes. I guess we could bring up, I'll add the minutes to this video. Okay, so we do have the minutes. Let's take a look at these minutes really quickly. They were filed after all that other stuff. The court noted the pleadings directed defense counsel to proceed. No viable claims. Directed counsel to address punitive damages, which is good. Nothing really jumps out at me. Okay, so there was the motion to strike was granted on the document that didn't need to be filed, and the motion for judgment on the pleadings was taken under submission. Then they later on granted so you saw the order granting. So after I filed the appeal, I had a conversation with the attorney. I can't remember if it was via email or phone. I think it was both. And they knew, here's where I think the case was weak under the standard of review for dismissal, but the case was even weaker because of the court's failure to allow amendment, and also because the court didn't send it to the justice court. There were too many ways for this to reverse, and the attorneys knew that. And I, at the time, was moving. If I remember correctly, Brittany and I had married and we were moving to Vegas. And so I was ready for the case to just go away. I wish that I had the gravitas to push the case all the way to the end and actually trigger some kind of publication. I hope that someday somebody does that, because the landlord-tenant issue continues to be a problem. But I did take a deal. Didn't have to pay any of the attorney fees or costs, and then they, of course, didn't have to pay a judgment. Everybody just walked away, and that was just flat zero on both sides. And I don't regret it now because of the fact that there was no transcript. The fact that there was no Javs video and that there was no transcript worries me a lot, even though I feel like I have a strong case to trigger a reversal based on the standard, based on the failure to allow amendment, and based on sending it to the justice court. Those are all three big things. The fact that I didn't have a transcript really worries me, because I don't know what the Supreme Court would have done. Without a transcript, oftentimes they'll just assume the judge was correct. So knowing now in hindsight that I wouldn't have been able to get a transcript of that hearing worries me so much that I'm actually glad that I took the deal. What I could have done instead, going back in time, was to insist on a transcript. And that would have possibly made me not lose that appeal. We'll never know, because since I took the deal, everything dismissed and closed out. So I don't have regrets. Wish I could have showed you guys a more exciting outcome, but at least nothing bad happened and I didn't have to pay any money. So in the end, a learning experience, frustrating for me, but also frustrating for the landlord. I don't think that they learned their lesson, because they have reviews all over YouTube, I guess in, not YouTube, sorry, reviews in, what's that app called? Yelp. That's what I meant. It starts with a Y. The Yelp reviews that I've taken a look at makes me think they're still doing the same stuff they've always been doing. It would have been nice for them to stop, but I think it's really due to the legal climate. It's not something that's just this landlord. I do not believe at all that this one company is the only company doing this. I feel like it's the rule, not the exception. And as long as the laws are set up in the way that they're set up, and the courts deal with these problems in the way that they deal with these problems, we're going to continue to see this conflict between landlords and tenants, and this sort of exploitation, this relationship of exploitation. That's all I have, guys. There is a Supreme Court case, but there's not really any point to look at it because it just missed out because we settled. Um, you know what I'll probably do is I'll probably just download the documents and attach them to the description below as well. It's just you're gonna just see maybe um, I don't even think I put a docketing statement in there. I don't think you're gonna see anything but an order dismissing because of the deal. So almost forgot the motion to retax costs. This is the mechanism that you use to challenge costs in Nevada. It's a little awkward, but that's what the statutes say. Standard introductory paragraph indicating I'm appearing in proper person, which means I don't have an attorney, and that I'm filing the motion to retax costs. There's a law. It says that within 3 days of a copy of a memorandum, then you can move the court upon 2 days' notice to retax and settle the costs. So it looks like within 3 days, you can file a motion upon 2 days' notice. I don't know what they mean by the 3 days and the 2 days. Like, which one is it? The court will set a hearing and they'll settle the costs at the hearing, I guess. The court entered a dispositive order in favor of the defendant. I filed a memorandum of cost. The motion to retax costs is timely. Defendant's taxed filing fees in the amount of $213 are not disputed. Okay, that makes sense. Photocopies and postage. Does not dispute that photocopies and postage are recoverable costs. I'm asking the defendant to prove up the actual costs that are incurred on opposition. Computer research. They tried to tax these as costs, huh? That's not allowed. There's a lot of cases that have come out since then, so it might be allowed now, at least in some way. I don't know. But there's no indication that the legislature intended for the law to include computer research as a taxable cost. Federal courts ruled that computer-aided research is a component of attorney fees, not costs. Prevailing party's entitlement to costs has no root in common law, and the statutory scheme outlining the taxable costs has to be strictly construed and complied. Yeah, I talk about this in the video, attorney fees and costs. So the 228.12 and legal research cannot be taxed. Teleconference services. Okay, talked about the arbitration. Okay. Looks good. That's it. Rule 5 certificate of service indicating this document was mailed to the attorney. Going into the aftermath, I filed, let's see, 1, 2, looks like 2, no, 3. Yeah, 3. No, that's just 2. I guess you can count the stipulations. So yeah, we're at 3. 3 documents, and they were all free filings, so I incurred $0 in costs. The notice of appeal I would have had to pay on, but I had former pauper status, so it was free. The Corazon Real Estate filed, let's see, 1, 2, 3, also 3 documents. They were all free filings, so they incurred $0 in costs as well. I didn't have an attorney, so I incurred $0 in attorney fees. They had an attorney, and there's some big stuff on here. So the verified memo of costs, I'd say 30 minutes. Let's see, reviewing all my documents, an hour. I mean, there's a lot of documents there, so we're looking at an hour and a half. The motion to retax, I already covered that. The stipulation, so the deal itself took like an hour to come to. So we're at 2.5 hours. I mean, I even had to go there in person to sign it and talk to them. So we're at 2.5 hours. Preparing the order granting, at least 2 hours. So we're at 4.5 hours. The notice of entry is negligible. So we're at 4.5 hours, but then we have the hearing with prep. So 2 more hours. So I'm going to take him to 6.5 hours. And then the arbitrations, they weren't long, but there were a few of them plus prep. So I'm going to just take it up to a solid 8 hours at the rate of $250 an hour. That's going to come to $2,000 in attorney fees for Corazon Real Estate. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.